Hello everyone, welcome to Law of Contract class. Today I want to talk about the second situation in which the contract is void because one party to the contract doesn't have full legal capacity to enter into the contracts. That is the situation when one party to the contract is mentally incompetent person. Now we move on to look at the second class of person who do not have full legal capacity to enter into contracts, which is mentally incompetent person. So the law protects people who suffer from substantial mental incapacity from enforcement of contracts. To be relieved of duties under a contract, the law requires a person to have been legally innocent at the time of entering into contract. So if you are a mentally incompetent person and you can be released from the contract to obligation, provided that you were so innocent at the time you enter into the contract. So that is the public policy to protect those who do not have full capacity to understand what he or she is doing from being unfairly affected by the agreements that they enter into at the time they were so innocent. By law, a mentally incompetent person is a person who in a state of legal insanity. So legal insanity is a state of contractual incapacity as determined by law. Insanity is defined by a legal dictionary to mean a mental illness of such a severe nature that a person cannot distinguish fantasy from reality, cannot manage his or her own affairs, or is subject to uncontrollable impulsive behavior. Such a person, by law, should not be held liable or responsible for his or her behavior. There are two standards concerning contract of mentally incompetent persons. They are adjudged innocent and innocent, but not adjudged innocent. Adjudged innocent. What adjudged innocent mean? Adjudged innocent mean a person who have mental problem and who have been announced or declared by a proper court or an administrative agency to be innocent. So in such a case, a contract that entered into by such an innocent person is void and unenforceable. I hope that you still remember what void contract means. Void contracts mean an invalid contract which cannot be enforced against either party. So if the contract entered into by a person, even one party is only, who is mentally unsound person, and that person already been declared by a competent court or a competent administrative agency to be innocent, and that contract is void and unenforceable, which means that not only the innocent person can walk away from the contract, the other parties who have full capacity to enter into the contract can walk away from the contracts as well. So the contract is unenforceable by the court. In that case, the court will not interfere. The parties will go with their loss and gain. A second type of mentally incompetent person is insane but not adjudged insane. So a person who is insane would mean who have some mental problem, but that person has not been asserted insane by a competent court or an administrative agency. That person is treated by law as an insane, but not an asserted insane person for the purpose of accessing their contractual capacity. And what is the consequence of a contract that entered into by an insane but not an asserted insane? That contract is generally voidable. And I hope that you still remember what voidable contract means. I just want to repeat. Voidable contracts mean a valid contract unless the eligible party choose to void it. Okay? So in this case, the insane person, the insane but not asserted insane, have the right to void it. Okay? Not an obligation. However, the competent party doesn't have the right to void the contract. Understand? Okay, I hope so. Of course, as I pointed out earlier, that if you want to claim that you do not have full contractual capacity, you are the one to prove. Okay, you actually bear a burden of proof. You have to give evidence showing that at the time you enter into the contract, you are insane. You are incapable of entering into the contract. The next type of person who do not have full legal capacity to enter into the contract is intoxicated person. So who is intoxicated person? An intoxicated person means the person who cannot understand the nature of the transaction. An intoxicated person usually are those who are influenced by drugs, usually addictive drugs or alcohol. And during the time that they are influenced or affected by drugs or alcohol, they do not understand the nature of the transaction that they are entering into. So in that situation, the contract is voidable at the option of an intoxicated person. And of course, the intoxicated person have to prove that at the time they enter into the contract, they were so intoxicated. And similar to the case of an insane but not asserted insane person, only the intoxicated person have the right to void the contract. The other party doesn't have that right. The other party means the party which has contractual capacity. So to sum up, in order for the intoxicated person to void the contract, he has to prove two things. The first one is he was so intoxicated at the time they enter into the contract. And the second one is that the other party who have a contractual obligation, who have a contractual capacity at the time entering into the contract, know that that party, the other party, was intoxicated. Okay? And of course, the party would claim intoxicated in order to void the contract have to prove. Okay? And even you can prove that you were intoxicated at the time you enter into the contract and you want to, it affirms you want to void the contract. The law allows you to do so. However, what is the consequence? Even though the intoxicated person have the right to disaffirm the contract, to cancel the contract, or to void the contract, he have to return the other party to statute quo. So do you still remember the term statute quo? would mean that the position before the parties enter into the contract. For instance, if you were drunk and you enter into the contract with the other side, with the other party to sell your car, and because you were intoxicated, you didn't know the value of the car, right? So you sold your car at the price with under the market value. So it doesn't matter whether it is under market value. When you want to cancel the contract, when you want to void the contract, you have to return to the other party the status quo, which means that if you receive 5 million for the car, and then you have to return the 5 million.